2, debate on clauses, part 3, debate on clauses 68 to 116 and schedule 3. The question is that part 3 stand barred. Charles Chevelle.
Thank you, Mr Chairman. I wonder if we could hear from the Minister and the Chair on a number of matters that are of particular interest to the opposition. As I said in my initial comments before the dinner break, to date the opposition has chosen to offer support for the legislation, but obviously the continued support of the opposition for the legislation is subject to being satisfied about the concerns that it wishes to raise. So the first matter that I would be very interested to hear the Minister speak on is the issue of how it is intended that the Commissioner, the Legal Services Commissioner, to be created by Section 70 of the new legislation is to function. This person is to be an existing employee of the Ministry or is to be appointed as an employee of the Ministry on taking office as the Commissioner. So the first issue is what is the guarantee, if any, that the Commissioner won't simply be a cipher for the Secretary for Justice, subject to, in particular, budgetary constraints around ensuring that the overall aims and objectives of the Act are met. Why should the Parliament assume, given the wording of the legislation, that there is any desire on the part of the government to see the Commissioner in particular take care that the objects of the legislation are met? What safeguards does the Minister think are built into the legislation to ensure that the Commissioner really does have regard to the purposes and the functions set out for the Commissioner, particularly under Section 71? Now, I know that I anticipate that if the Minister does choose to take a call and reply to the issues that I'm raising, he might point to Clause 71.2, the duty to act independently in respect of the functions set out in proposed Section 71. But really, is that enough of a safeguard given the breadth of the transfer of powers that's proposed? Because, of course, what's happening here is that an independent body, at the moment a Crown entity at some arm's length from the Crown, is being taken into the Crown itself, and presumably there is a reason for doing that. Presumably one of the reasons for that taking of powers closer to the Crown is an economic one, and I think it would be helpful if the House, or rather the committee, were to hear from the Minister as to whether or not he feels that there are sufficient safeguards as to the exercise of those powers, particularly as to whether or not they won't simply be able to be exercised at the direction or the discretion of the person who is in charge of the Ministry of Justice. The second point relates to the ability of the Commissioner to delegate powers, functions or duties, which is set out under Clause 72. Because although there's a power of delegation for the Commissioner, there's no guarantee that once delegated powers are exercised, they are going to be exercised in an independent way. So even if the guarantee of independence conferred by Clause 71.2 is pointed to by the Minister, we still have the ability to delegate powers under Clause 72, and there's no guarantee that the delegate of the Commissioner, no requirement that the delegate of the Commissioner ought to act independently. So I think those are significant matters that we really do need to hear from the Minister about. The next issue that the opposition has a particular concern about relates to subpart 2, and this is the quality assurance provision in the legislation. At the moment, there are a couple of quality assurance, Mr Chairman, there are a couple of important quality assurance provisions in the existing legislation. There's a public advisory committee, which when we come to debate part 4 we'll see is disestablished by clause 118. And there is also a review panel to be disestablished by clause 128 of the bill. Now, what's proposed in the place of these two means of assuring that legally aided persons receive reasonable quality in terms of the legal services that they consume is the regime to be set up by clauses 74 through to 83. And it would be helpful, I think, to hear from the Minister as to what deliberations have occurred inside the Cabinet as to comparing the existing quality assurance provisions and assurance as to public input into the system with the proposed provisions. Has there been such an exercise? Is there any guarantee that the House can take from the provisions that are contained in the bill as to whether or not this regime is likely to be superior or inferior to the one that exists at the moment? The other issues that it would be helpful to hear from the Minister about in respect of this particular part relate to those that are contained in subpart 3. Subpart 3 deals with community law centres. Clause 94 empowers the Secretary to enter into contracts with community law centres so that they can provide services to communities on the terms of the arrangement entered into with the Secretary. And then there are provisions concerning reporting and auditing. Now, it's clear, I think, and hopefully a matter of consensus across the House, that community law centres provide a very helpful and important service to the community. Again, it would be helpful, I think, to hear from the Minister and the Chair as to how these provisions compare to the existing law, and in particular how it is intended on the part of the government that the very good service, the very good level of service provided by community law centres at the moment is going to continue under the regime to be set out in the legislation that's being considered by the House, sir. Sir, finally, as far as the matters that I wanted to raise in this short call are concerned, I was interested in the Minister's view on subpart 5, in particular clause 108, the limitations in respect of disclosure of information. Now, there's a provision in clause 108.1 that every person should have the same privileges in relation to giving information, answering questions and producing documents in respect of an application for legal aid for a civil matter as any witnesses have in court. And then there are provisions in the remainder of clause 108 that effectively derogate from that provision, and it would be useful, I think, to hear from the Minister as to the levels of protection that are actually provided for people who actually go through the process of providing information. What are the protections that are intended to apply to those people, and how do they compare to the current law? Is this House being asked to derogate from those protections, or is it actually supplementing them? I fear it's the former, and I think it would be helpful to hear some sort of assurance from the Minister on that point.